Good afternoon, everyone. I am Attorney Wilda Pomales. I am the family law attorney here at the Meredith Legal Legacy Legal Team Firm. Today, I will be discussing jurisdictional issues and family law matters here in Florida. And so, why do we need to discuss jurisdiction here in Florida? We know we're in Florida, and so why does it matter? It matters because it determines whether cases can be heard in front of the court if Florida has jurisdiction or not. How is it that we need to understand that jurisdiction issue? And whether you bring in a divorce case or a child custody case or court case, any of those legal matters in family court, the court first needs to determine if it has jurisdiction over that case, over the parties. And so that's why it's very important to know whether you're filing correctly in the court that is able to hear your case. Because the worst thing that could happen is you file, you pay your petition fees or whatever fees are needed, and then you find out that you can no longer proceed in that court and you've lost the funds. You've lost the money. There are no refunds when you file incorrectly. And so, what are we talking about when we're saying jurisdiction, right? What are we really discussing here? And so, in family cases, you have two types of jurisdiction that the court must first satisfy, and that is subject matter jurisdiction and personal jurisdiction. And so, what is subject matter jurisdiction? And this refers to whether the case, the type of case that it is, such as family cases, can be heard. And so, here in Florida, the circuit courts are the ones that hear all family matters. So, whether you're doing a divorce, you're doing child support case, alimony, motions, all that stuff, it's going to be in circuit court. And so that is the subject matter. And so, what is personal jurisdiction? And that is, does the court have authority over the people? So, you're trying to file a case, you're trying to get divorced. And so, can the court hear it? And does the other person have to appear before this court, this judge? And so, how is it that we can get personal jurisdiction over somebody if somebody doesn't live here, right? And so, what are the avenues that you can use to get that personal jurisdiction over someone? And the example that we get a lot is I live here in Florida, I want a divorce, or I want to establish time sharing, and the other party, the other parent does not live here, they live out of state. And so, what is it that we can do to get them to be able to participate or be compelled to participate here in the state of Florida? For Florida court to have jurisdiction over divorce, there are certain residency requirements that must be met. And so, one of them is okay, so you want to start a divorce, have both of you lived, or at least one of you lived in the state of Florida for at least 6 months before filing the petition, right? So sometimes people want to file it, they know it's going to take a while, and so they think, okay, the 6 months will pass and I will meet that Florida residency requirement. But that's not the case. You have to live in Florida 6 months prior to filing that divorce. And so we're just talking about divorces here. And so it's pretty straightforward. If both of you live here, then Florida can proceed in your divorce matter. But if one of the spouses resides in a different state, then it can get a little bit more complicated over there. And so, what happens if one of the spouses lives in another state? How can Florida establish that personal jurisdiction? We already know that Florida Circuit Court can hear the divorce matter, but how can it establish personal jurisdiction over that non resident spouse to go over such things as a divorce, property division, alimony, things like that? Usually, Florida can achieve that through sufficient contacts if the other spouse has sufficient contacts in Florida, such as owning the properties. If you jointly own a property or the other spouse owns a property by themselves here in the state of Florida, then you know you have jurisdiction through that route. Or they conduct business here in Florida. Or if the marriage itself was based here in Florida. So if Florida was the last place where you both lived as husband and wife, and then suddenly the spouse moves away to a different state because they have family or they just want a break and they move out of state, then you can definitely start the process here because this is where you lived last as husband and wife. And so this is where the marriage itself started. It gets a little bit different when you are dealing with children and children issues as well. So here I was originally talking just to determine things like property division or alimony. And so what happens when children get involved? And so child custody jurisdiction is governed, and we're going to go over legal terms here, but it is governed primarily by the Uniform Child Custody Jurisdiction and Enforcement Act. And so we just simply say for short, UCCJEA. And so this has been adopted by Florida. And what that means is that the UCCJEA aims to prevent jurisdictional conflicts between states. And we want to make sure we have rules as to which state can govern over the time sharing issues. And so under the UCCJA, Florida can assert jurisdiction in child custody case or time sharing cases if the child's home state is Florida, right? So we need to first determine what's the child's home state. And it's typically defined where a parent or guardian of the child has lived at least 6 consecutive months before starting the petition. If you've lived in Florida, you're the guardian or one of the parents, and you've lived in Florida with the child for at least 6 months prior to starting the petition, then the courts will generally have jurisdiction to make that initial determination. Excuse me. And so if the child has recently moved to the state of Florida, then you're going to have possibly another court, another state that has jurisdiction over that child. And so you will have to determine first if if you moved with the child here and the other parent is still in the other state, it could possibly mean that the other state has that jurisdiction to determine that initial custody case. What will happen is you will need to contact the other state to determine whether you're trying to modify any type of child custody or child support. You will have to notify the other courts and see if they will relinquish that case and let you continue here in Florida. But if nothing has been started, then the other party can object to this jurisdiction being Florida and have you be pulled into the other state. And so what happens with child support? Again, these are acts that are put in place to give you rules. If you want jurisdiction over child support matters, that is governed through the Uniform Interstate Family Support Act, and UIFSA is what we call it, UIFSA, and that is intended to streamline that child support case. And under that act, the state can establish, they can modify, enforce child support if it has continuing exclusive jurisdiction. And how do Florida courts have that continuing exclusive jurisdiction? And so Florida will have that to modify any or enforce any child support if either the child or one of the parents still lives in Florida. And so if you get a child support order entered here in Florida, one of the parents moves away, you can still continue to try to modify or enforce it here through the Florida courts if a parent still lives here, right? And so we can do it that way. If everybody moves out of the state, both parents, the child moves out of the state of Florida, and then you're trying to modify or enforce, then you're going to have to go through the courts of the new state where you live and have established that residency. So it just depends on what the situation is. Typically, if a parent still lives in the state that originally entered that order, then that state continues to have that continuing exclusive jurisdiction. And so you will have to go through that state. Unless the other person voluntarily wants to be subjected to the Florida jurisdiction. And so what happens if one party lives out of state or even out of the country, and we have those jurisdictional issues becoming a little bit more complex? And there are rules that we have to abide by in Florida statutes. And so we have what is called the long arm statute, which allows Florida to obtain that personal jurisdiction so they can assert that personal jurisdiction over that out-of-state resident if they have sufficient contact with Florida. And again, such as maintaining property or conducting business here in the state of Florida, we can get that done. And again, this is only if the party is not willing to voluntarily subject themselves to this Florida jurisdiction. And so We've had cases where a party is seeking to get divorced and they've met the residency requirement, which means they've lived in Florida for at least 6 months prior to filing that petition, but they moved from a different state. So they lived with their spouse as husband and wife in a different state, moved to Florida, trying to get that separation between the two. And then now they want to get divorced here in Florida. Florida does not have personal jurisdiction over that other spouse because the marriage did not start here. They may not have any property here. The other person may never visit Florida at all. And so, how do we get them over here? And the easiest way is to have them volunteer, right? And so they can waive that personal jurisdiction and say, okay, I am in agreement with the divorce, and we can go through the process, and they will sign that waiver and we'll submit that to the courts and we can go through the process of getting divorced. How about if they do not sign that waiver and they don't want to start discussing alimony or any financial issues? Then what you can possibly do is bifurcate. So you can separate the issues and say, go to Florida courts and say, I want to get the divorce and handle the other monetary issues through the state that has that jurisdiction over that personal jurisdiction over that other spouse. And so you can get divorced, but the court will reserve on the other issues because it does not have jurisdiction. So they cannot enter an order dictating what will happen with the alimony or anything like that. And that goes the same with the children issues. And so if the child does not live here, you move by yourself and the child and the other parent live in a different state, you can get divorced, but the court here in Florida cannot determine what that time sharing schedule will be if the other parent does not agree to it. So there are different ways that you can get around that, but you definitely need to speak with an attorney to see what's the best way, what's the best avenue to take, because you don't want, again, to be spending and filing these petitions in different courts and be spending that money when it's unnecessary. And we know right from the beginning that Florida will not have that jurisdiction. And so the other issue that we have seen is parties filing in a county that does not have jurisdiction. For example, we had a client this week come to us and they want to file for a divorce, but they moved to Polk County, I believe, and everything, the house, the other spouse, everything, the marriage started in Osceola County. And so at that time, with the divorce, the spouse that now moved to Polk County cannot start the case in Polk County because that county does not have jurisdiction. And so it'll be more of a burden for the spouse that stayed in the property and in Osceola County to be able to travel and go to Polk County. So you will have to file where the respondent lives or where their property is located at that county so that the court can properly hear that case. So if that happens, let's say you do get served with documents and you know that you don't have any connection to that county, you can file a motion and transfer the case over to the county that it belongs in. Now, there are fees again, so you want to make sure that these petitions are getting filed in the correct county because there are transfer fees that the petitioner will be responsible for if they originally filed in an incorrect county. And if it gets transferred, if the court finds that, yes, the case needs to be transferred over to the correct county, then the petitioner will have to file and pay for that transfer fee or the case gets dismissed. And so it is in the petitioner's best interest to file the original case in the correct county, as well as serving the people in the correct counties. Now, it's different with paternity cases. So that's in the case of a divorce. Paternity cases tend to go wherever the petitioner or respondent reside. And so typically the parties, for the most part, reside in the same county. And so that makes it easy. But whenever one of the parties resides in a different county, they'll choose their own county for the convenience. And so you tend to want to file in the county where the child resides because the daycare may be there, the school may be there, teachers may be there. And so it's easier if you need to call any witnesses to testify in any of the hearings or anything like that. It's easier for them to travel and just looking for the easiest way to carry out your case. And so typically it's filed in the county where the child resides with one of the custodial parents or whatever the case, the guardian may be. So those are just jurisdictional issues that you want to be aware of. And let me just check. I don't think we have any questions here. If anybody has any questions, feel free to chime in and put them in the comment. But feel free to, if you have any questions, I'm not sure of where you can file, give us a call. We can schedule a consultation and get over those questions before you decide to start the process on your own. And again, spend money that can otherwise go for other necessities. And so feel free to give us a call. We can answer all those questions, whether somebody lives out of state or just in a different county. We can assist with any of those issues, any family issues. And as well as our services are offered in Spanish as well. We are able to assist with your family issues in Spanish if that's needed, or if you know anybody that needs that. So at this time, I think, let me just confirm, I don't think we have any questions here. We will end this. And if, again, you have any questions, feel free and give us a call. Have a good one.